Now, this episode of The Dissection is going to be hot, and it may get me into some trouble. But I have to tell the truth, and I have to keep it real. So I'm going to tell you how I see it, and you're going to make a determination whether or not I was fair or unfair. As you know, the Judicial Service Commission is going to sit tomorrow to choose judges. And as you know, the MK leader in parliament, the leader of the party in parliament, the official opposition of South Africa, has been barred from this particular stage. And there's something wrong with that. There's something wrong with that which destroys the credibility of the whole process. Watch till the end and you're going to understand everything, but I have to go through a sequence of framing and factual informing before we get to the juicy bits. So the Judicial Service Commission was established. The Judicial Service Commission was established in terms of Section 178 of the Constitution and consists of 23 members. In terms of Section 1785 of the Constitution, the JSC is entitled to advise the national government on any matters relating to the judiciary or administration of justice. Additionally, it performs the following functions. A, interviewing candidates for judicial posts and making recommendations for appointment to the bench. This is the crux of the issue. And B, dealing with complaints brought against judges. Who are the members of the JSC? As I said, it's currently composed of 23 members. The first member is the Chief Justice of the Republic of South Africa, Chief Justice Mandisa Maya, who is the chairperson of the JSC. Then the second person is the President of the Supreme Court of Appeal, Madam President M.B. Molemela. The third person is Judge President D. Mlambo. He's the guy who wanted to become the Chief Justice, but got chowed in the previous interviews by the JSC. If you remember, Advocate Dalimpofu, Julius Malema were in there and they grilled him and asked him very tough questions. Well, he still sits on the JSC. He gets to choose judges. Somebody who faced serious accusations in his own name around some of the things that he was accused of doing in the bench. But you can go Google that. Right. The other person who sits on this JSC, the Minister of Justice and Constitutional Development, Ms. T.P. Thembise Melane. Two practicing advocates, Advocate K. Pillay, Senior Counsel, and Advocate J. Kane, Senior Counsel. Two practicing attorneys, Mr. M. Mr. M. Notiesi and Mr. M. Mangena. A professor of law sits on this. In this instance, it's Professor C. Marumohai, and 6 persons who are designated by the National Assembly. And this is where there is a dispute. These 6 persons, as they are right now, you've got Ms. S. Lechanyane, you've got Ms. S. Fasia Hassan, who is an MP of the ANC. Then you've got Advocate Glenis Breitenbach. She is a DA MP. You've got Dr. John Hlophe, MK. He's still added as a member of the JSC because they actually need all 23. Otherwise, there's an issue around whether or not they're fully curated. So if they don't have the whole 23, then there's a question. Although members of the JSC may be absent in a particular hearing or deliberation, if you will. Then you've got Mr. Julius Selo Malema of the EFF. Then you've got Mr. Athol Trollip, who's an MP, I think, Action SA. Right. So those are the 6 persons. So the dispute or the issue rests with the leader of the opposition in Parliament, Dr. Mandlakaise John Hlophe. Right. There are other members, 4 permanent delegates of the National Council of Provinces, Miss R. Mtsweni Tsipane, Advocate Nonkonyane, Mr. K.E. Moimang, and Mr. Gotzel. Right, and Gotzel. These are the National Council of Provinces. So as you can see, the National Assembly sending 6, Council of Provinces sending 4. That's 10 overall, politicians, if you will. Then there are 4 persons designated by the president. And in this instance, you have got Ms. S. Matolo Dlepu, you've got Advocate Tembeka Ngwaitobi, Senior Counsel, and he's been representing the president in a variety of issues. So You can make whatever conclusions you want in that respect. Miss N. Shabangu Ndawe and Advocate S. Baloyi. So the president designates a few people. The National Assembly designates a few people. You've got the National Council of Provinces designating a few people. You've got some sitting judges. You've got academics. You've got 2 practicing attorneys. All of this really is the who's who in terms of the elites of the legal fraternity and senior political leadership. And it's supposed to balance each other out so that the best judges are chosen. Very critical to say at this particular point, the choice of judges in and of itself sometimes can be very political, it can be very messy and dirty, and it can have long-reaching implications. If you were watching the American political landscape, you will have seen that there are some judges that Donald Trump chose who were then instrumental in some of the decisions that have now been made, some of which have favored him. So if I'm pointing this out, whether it's Roe v. Wade, whether it's what presidential powers does Donald Trump have, which is something that has actually perhaps protected him from being prosecuted before the election, you have these particular outcomes for a politician. And people are very aware in the American landscape that the choice of judges for high courts, Supreme Courts, can affect policy, because those judges have preferences, they've got history, they've got their own political ideologies. They are human beings after all. Some of them go to church, some of them support the political parties that you support, or some of them hate the political parties that you support. That's a reality. They have met these politicians, and some of them think that they are better than the politicians. Some of them think that they are versions of God on earth. Judges can be quite arrogant people. Not always, but sometimes. And this is all stuff that we have to be aware of. They're not perfect, and it's fair and important to have conversations about the judiciary. To bring it closer to South Africa, when the JSC set to determine who should be the next Chief Justice, a lot happened. A lot happened because there were leaks or accusations that Judge Mlambo, the judge president of the Gauteng court, had participated in harassment of women. It was reported. And then there was even an accusation that the Chief Justice, the current Chief Justice, Mandisa Maya, is the one who spread those rumors. It got very dirty. It got very dirty. And it's one of the reasons why there was a change, and Advocate Dalimpofu was removed. One of the reasons why he's hated is because he's one of the people who removed the person who was supposed to be the preference. Even the reality, by the way, is that after all of this, the other mess that came out of the last selection process is that Deputy Chief Justice Raymond Zondo was not supposed to be the choice. He was chosen by the president, and it seemed as if the president chose him because he protected him in the State Capture Commission. Number one, he was one of the people who was coddling him in the cross-examination, answering on behalf of the president, laughing with the president in the middle of that cross-examination. Then he ignored parts of the State Capture testimonies which had pointed in a direction which went in the president's way. So for instance, Andile Ramaphosa received money from Bosasa, which was supposed to be this grossly corrupt organization and entity, but that never made it to the State Capture Commission report findings. And also there were accusations made about Glencore that somehow were ignored, even though it turned out later that Glencore paid billions, over 20 billion rand in America and the USA for bribing African politicians, for manipulating markets, and for seeking out political relationships in order to get contracts in the countries where they operated. Where? In Africa. Think about that. Think about that, right? So he wasn't chosen by the JSC. He wasn't recommended by the JSC. The Deputy Chief Justice Raymond Zondo, they recommended Mandisa Maya. She eventually became the Chief Justice. But the point that I'm making is that these processes are messy. And there are various NGOs which participate in this process very loudly. Judges Matter, Freedom Under Law, etc., etc. And if they don't get what they want, they complain. They go to the media. They go to courts. They try to push through the judges that they think are the right judges. But they're not part of the JSC. They're not constitutionally selected to be part of this process. But they still want to participate and influence and shout at the other judges to let them know that, hey, you have to choose our guy and our person, otherwise there will be consequences. We'll talk more about this later. Let me give you the facts and timeline of this particular issue. On the 9th of July 2024, the National Assembly designated to the Judicial Service Commission a member of parliament, being a former judge who was on 21 February 2024 impeached by the National Assembly for gross judicial misconduct. Dr. John Hlophe is an MP and the parliamentary leader of the MK Party, which is a political party duly represented in the NPA. It is not only duly represented, it is the official opposition. Dr. John Hlophe is a former judge of the High Court and held the position of Judge President of the Western Cape Division of the High Court for over 20 years. The National Assembly's designation of Dr. Judge John Hlophe, now what am I saying? Dr. John Mandlagaise Hlophe, right? We'll call him, he's not a judge anymore. Dr. Hlophe triggered 3 applications. The Democratic Alliance, Freedom Under Law, and Corruption Watch issued 3 separate applications on 19 July 2024, on 25 July 2024, and on 30 July 2024, respectively, right? And in these applications, these were their requests. They wanted a review of this decision. And what they were arguing is that the National Assembly committed a material error of law in that it failed to properly exercise its discretion in terms of Section 178(1)(h) of the Constitution. Alternatively, that the National Assembly did not recognize that it had a discretion at all. So either they didn't properly use their discretion or they failed to recognize that they had a discretion. Number 2, the designation of Dr. John Hlophe to the JSC is incompatible with the JSC's obligations under Section 1654 of the Constitution. Number 3, the other ground of review, that the National Assembly took irrelevant factors into consideration and failed to consider relevant and material factors in reaching its decision. And number 4, that the National Assembly's decision was unreasonable and irrational. These are the things that the 3 entities that made this request to the courts argued. Right. So before we go into how the court viewed those particular arguments, and they were requesting an interdict in part 1 and part 2, requesting a final determination on these issues, right? And this matter is likely to go all the way to the Constitutional Court because this particular, some of the decisions have been granted review. They've been granted, so the appeal actually has been granted. Right. Not review, appeal. So just to go over the Hlophe side of the situation, Dr. John Hlophe was appointed as a judge in the Cape Provincial Division in 1995 and elevated to the position of Judge President of that division in the year 2000, right? The justices of the Constitutional Court, led by Chief Justice Langa and Deputy Chief Justice Museneke, lodged a complaint to the Judicial Service Commission against Dr. John Hlophe, whereupon the matter was referred to the Judicial Conduct Tribunal. After hearing evidence and argument, the tribunal provided its report and recommendation to the JSC on 9 April 2021. It concluded that Dr. Hlophe was guilty of gross misconduct in that his conduct breached the provisions of Section 165 of the Constitution in that he improperly attempted to influence the 2 justices of the Constitutional Court to violate their oaths of office. By the way, he approached them about a matter which had something to do with Jacob Zuma, who was president at the time. B, his conduct seriously threatened and interfered with the independence, impartiality, dignity, and effectiveness of the Constitutional Court. And C, his conduct threatened public confidence in the judicial system. The JSC considered the tribunal's report and recommendation in accordance with Section 20 of the Judicial Service Commission Act 9 of 1994, whereupon the majority agreed with the tribunal's findings and found that Dr. John Hlophe was guilty of gross misconduct. The JSC concluded that Dr. Hlophe's conduct rendered him guilty of gross misconduct as envisaged in section 1171A of the Constitution, in that he attempted to influence improperly Justices Nkabinde and Jafta to decide matters that were then pending before the Constitutional Court in favor of Jacob Zuma. Having considered the JSC's report, the National Assembly Portfolio Committee on Justice and Correctional Services recommended to the National Assembly to remove Dr. Hlophe from office. On the 21st of February, the National Assembly resolved with a majority vote, right, 305 yeses to 27 nays, to call on the President to remove Dr. Mandlakaise John Hlophe for gross misconduct. On the 6th of March 2024, Dr. Hlophe was removed from office by the President, acting on the resolution of the National Assembly in terms of Section 177 of the Constitution. So, by the way, most of the votes to remove Dr. Hlophe came from two political parties, the ANC and the Democratic Alliance. This was one of the GNU moves, right? So two political parties decided that, nope, we don't want this guy. It was, in part, a political decision to revenge against the Zuma faction of the ANC and to entrench the Ramaphosa faction of the ANC. Some of these disputes have been long-standing. It's political in nature and has had a bearing on contestations of power between Jacob Zuma and President Cyril Ramaphosa, current President Cyril Ramaphosa. So you need to be aware of that. And as you know, the DA hates Zuma, anything to do with Zuma, and they are fully against anything to do with Zuma. So Hlophe was removed, and coming a little bit forward, the JSC will hold interviews tomorrow from the 7th to the 11th of October, and several vacant positions will need to be filled, right? One of the positions, and this is very important, why Freedom Under Law, DA, and Corruption Watch wanted Hlophe out. One of the positions that's going to be filled is a position that was held by Dr. John Hlophe until he was impeached. There are 4 vacancies in that division, right, of the Western Cape Division, and 3 vacancies in the Supreme Court of Appeal. And then there are vacancies in other divisions. So 5 appointments are in the Western Cape Division. This is also the court that hears a lot of applications first if they pertain to disputes that come out of Parliament. It's a very important court, very significant. Okay, let's now go into the issues. I think I've covered everything that I wanted to cover as a preliminary thing. Okay, just some rules that you need to be aware of, some laws and rules, etc. Section 167(4)(e) of the Constitution deals with the Constitutional Court's exclusive jurisdiction and stipulates that only that court may decide that Parliament or the President has failed to fulfill a constitutional obligation. This pertains to whether or not this court, the Western Cape Court, could have had this application or had jurisdiction to hear this application in and of itself. Rule 9 of the National Assembly reads as follows: conventions and practices relating to the business of the House and its committees and other forums are established by agreement amongst political parties and parliamentary office bearers, and may be varied by agreement amongst them and reviewed from time to time as decided by the Rules Committee. That's National Assembly Rule 9(1). And Rule 9(2) says conventions and practices must be consistent with the provisions of the Constitution. These rules, orders of the House, rulings and directives and guidelines of the Rules Committee. So part of the dispute is whether or not there's jurisdiction, whether or not, in fact, the decision was reached in a correct way as per the conventions and practices of Parliament. Parliament has chosen many people to be in the JSC, and there's never been a problem. Some of the people chosen have had accusations against them, such as Glenys Breitenbach. She was accused of misconduct when she was in the NPA, right? So there are some issues that come up as a result of the moves that have been made. So this is what the court said as its reason for the decision. This is their reason for the decision that they made to grant the interdict. We are satisfied that the National Assembly's decision to designate 6 of its members to the JSC, including Dr. Hlophe, amounts to administrative action under PAJA. It is an organ of the state, either exercising a power in terms of the Constitution or exercising a power or performing a public function in terms of any legislation. That's the first thing that they said. In exercising such power, a decision was taken which adversely affects the constitutional rights of South African citizens and has the potential to affect the rights of future applicants applying for judicial appointment. No doubt, the National Assembly's decision was not a legislative function excluded from the definition of administrative action, an aspect which the Speaker does not take issue with. Neither Dr. Hlophe nor ATM further denies that the decision amounts to administrative action. Only MK states that PAJA is inapplicable. In any event, if PAJA might be held to be inapplicable, the review court would be entitled to adjudicate the dispute based on the doctrine of legality in due course. So basically, they're saying that whether it is an administrative action or not, it's still an action that is reviewable. Number 3, what the court said in terms of its decision, bearing in mind the objective facts and submissions of all the parties pertaining to the grounds of review, we are satisfied that at least a very strong prima facie, there's that word again, has been made, prima facie case has been made out to be successful in the review applications contained in Part B of the 2 respective applications. We decided to postpone the freedom under law application for review as mentioned earlier, and thus it is not desirable to say anything more. So they're not going to consider the full arguments for review as made by freedom under law, because there are some big technicalities there that need to be considered, big legal principles as well. So finally, they said, an applicant for interim relief must show that it is likely to sustain some harm of irremediable or irreversible character. To wit, they must show a reasonable apprehension of irreparable harm. So what the court said is that Dr. Hlophe was found guilty of attempting to influence judicial deliberations, and thereby he became the first judge to be impeached. Mr. Zuma, the former president of the country, was on center stage in the Constitutional Court litigation at that stage. He is the leader of MK, the party that nominated Dr. Hlophe to be designated as a member of the JSC. Then they said something which I have an issue with, I'll explain later. Although there's no pending litigation to set aside any of the decisions taken against him, Dr. Hlophe made his intention clear. He intends to persist in litigating not only the JSC but the NA. Why do I have an issue with this? You can't be prophetic. Can't be prophetic. You can't evaluate as a court things that have not happened based on what someone said, because they could or could not do that. You can only evaluate anything based on what has happened. And the courts have done this before, where they said, well, Zuma will do this in the future. And I had the same problem with it. You can't be prophetic. Jesus Christ did not give prophetic powers to judges and members of the JSC. He did not do that. So that's a bit of a problem. Anyway, they went on to say, this is ironic in that he has been designated to the JSC and is presently an MP in the National Assembly. What they then say is that all 3 parties made valid points indicating the legitimacy of the JSC's processes would be tainted, which cannot be repaired later if Dr. Hlophe is allowed to participate in the JSC interviews and deliberations. This will undermine public confidence in the JSC. These were the reasons for the court decision granting the interdict. Pay attention to that last one. Pay attention to that last one, right? It's important. Pay attention to that last one. Right. A separate interdict was applied for in Gauteng, and this was heard by a single judge who did not grant the interdict to MK. I'm going to talk about all of this now. Got some points I want to make. This is the stuff that will get me in trouble. Okay. Separation of powers doctrine is important. That's my first point. We separate the functions of the legislature, the executive, and the judiciary. And what this does is it undermines the separation of powers doctrine. The question fundamentally is, should you as a political party be able to use courts to force Parliament to see things your way? If Parliament has procedures, traditions, processes, and they work the way that you want 90% of the time, you choose Advocate Glenis Breitenbach, nobody complains as the DA, then MK chooses Dr. John Hlophe, then you're like, no, it's not rational. It's not rational. It's always been rational, but this time I think it's the same DA. Something is wrong with this particular process. Something is wrong. And this is why I'm saying this stuff will get me into trouble. I'm going to say it anyway. The DA understood the precedent and the rules of parliament of choosing members and is now trying to add new criteria for who gets to sit on the JSC. All members of parliament are equal. And what they're trying to do is to create a new set of memberships standards for the MPs, for those who are fit and proper to be on the JSC. That's bizarre. That is bizarre. The question then becomes, what does this mean in future for other appointments that are made by Parliament? Does everyone now have to go through metrics of assessment that are chosen by the NGOs and billionaires or rival political parties? So now the Democratic Alliance is saying, we can come in and talk to the manager when you make a decision as a political party and make a rational decision on your benches around what you want to do. That's a problem. And I hope you can see why it's a problem. It's very messy. It's very messy because in future, the DA, Corruption Watch, Freedom Under Law can go to the courts. For example, if Gayton McKenzie tomorrow is appointed Minister of Police by the President, they will then go and say, no, this is irrational, unreasonable. It's a violation of PAJA because he was a convict and it's irrational and harmful to place him in that position. It's prejudicial to the criminal justice system and perceptions of the criminal justice system. A lot of this is subjective. But now when they do that, they then usurp and encroach on the mandate of the president. And then they put courts in the position where courts have to now start becoming co-politicians to make subjective political decisions. Because Gayton qualifies, he meets the criteria. Whether you agree or you don't agree, he meets the criteria to be a member of parliament. Dr. John Hlophe meets the criteria to be a member of parliament. Advocate Glenis Breitenbach meets the criteria to be a member of parliament. And that is sufficient. They are fit and proper to make laws, and they are given a mandate by the public who voted for them to sit in various entities. The reason why you can't just have ANC members choosing judges is because they will end up choosing judges who favor their party and do things that favor their party leadership. So you need to have opposition. The DA cannot be refereeing the other opponents to its own party. It's a contested space and it's contested for a reason. These decisions that have been made by the DA are actually the attack on the Constitution that they said MK was doing. Do you remember? They say, no, doomsday, we are preventing those who are attacking the Constitution. This is an attack on the Constitution. My opinion, I'm telling you how I see it. It's Sunday, I have to tell the truth. My second point, there's a real risk here of judicial overreach. It seems that the courts are overextending their power by effectively giving a red card to a legitimately chosen member of the JSC. The judges, the 5 judges who granted this interdict, one of them is a deputy judge president, senior, are effectively getting to decide who chooses the judges before the match. That's like you going to idols and then choosing, no, I don't want Somizi or I don't want this one, because there's an issue there. And they are saying that they are making this decision to preserve public confidence, but I'm afraid that they are undermining the very same public confidence. Now, their hope, not the judges, the hope of the system is that views like mine will never get heard, and therefore everyone can act like this is normal. But this is not normal. This is very abnormal. It's very abnormal, what is happening here. Right, so that's my second point. My third point is that this is very prejudicial to the voters of the MK party. The voters, more importantly, 2.5 million people voted for the MK party. Whether you like it or not, they gave them a mandate. And that mandate now has put them in a position where they are the official opposition. And their job is to hold the government of the day accountable. Their job is to execute their constitutional obligations. And they don't need permission to do that. They got the permission from the voters. The DA, big business, whoever, they cannot prevent that. South Africans chose them. Now, when the judges said what they said, right, that this is going to be detrimental to, they said that when you get an interim interdict, you must show that there's a harm which is irremediable or irreversible, right? Or that there is a reasonable apprehension of a harm. There's a reasonable apprehension of a harm for the MK party voters, 2.5 million of them. And there's a reasonable apprehension of a harm because this process will not be done again. And this is significant because remember they're choosing Western Cape judges, 5, right? Western Cape judges. Let's go back and think about this. Why I'm saying it's irreparable harm. It's irreparable harm because the judge president of the Western Cape will sit possibly for decades. Hlophe said for decades. And this is the court which often hears disputes arising out of parliament before they first go to the constitutional court. Let's say they choose a judge there who's against MK, against EFF, and starts making decisions as judge president. Because the judge president has a lot of power. They get to choose which judges sit, and they sit with those judges, get to know their views, preferences, proclivities, ideologies, etc. So if a judge president wants you to lose the first round of a case, he can make it happen by who he appoints onto your case. That's the power of a judge president. That's why there needs to be a balance of power, checks and balances, so you make sure you're choosing somebody there who's fair. Now, Dr. John Hlophe is someone who has experience in the court system, but particularly experience in that court. He also has a PhD from Cambridge University. Very few people can get into Cambridge University. He's one of the people who did, and one of the people who came out with a PhD. That's nothing insignificant. So he's a scholar. He's got 20 years of experience. This particular moment is unique because he also has specialized knowledge of the Western Cape system and those particular individuals who want to be judges there. Some of them want to be judge president. They are currently judges. He's worked with them. They worked under him for years. He uniquely could have brought insights to the process that are critical to the decision making. Yes, he is conflicted in that some of these people are his rivals and work to get him thrown out of the bench. But other people are also conflicted, but they sit on the JSC. Glenys Breitenbach of the DA had a conflict of interest with the NPA, but she has been useful in parliament in bringing specialized insight. When you sit and people work under you, right, you get to know who's incompetent or competent. So Hlophe could have asked important questions to judges who want to become Western Cape president to expose their knowledge or lack thereof of the law. Now, what happens if MK wins this appeal and he can't sit? There's an irreparable harm to the whole bench and process. There is a tarnishing on the other end. And this is why I think that either this interdict should not have been granted, or the interdict to prevent the JSC from sitting until this matter is resolved should have been granted. I'm going to talk about that a little bit more later. There's a fourth point I want to make. It's an important point. Billionaires, in this case Michel Leroux, are influencing 4 pillars of democracy, right? The first 3, judiciary, legislature, and the executive. And they're helping the political party, the Democratic Alliance, take 3 bites of the cherry in this legal argument. I'm going to explain what I mean by this. It's very important. Michel Leroux, the founder of Capitec, funds Freedom Under Law, and he funds Corruption Watch. He also funds, by the way, Amabungani, who work with Daily Maverick. So he has a media arm, as well as Corruption Watch and Freedom Under Law, who frequently appear in News 24 and in Daily Maverick. Michel Leroux also funds the Democratic Alliance, and in the last 3 years, he spent 115 million rands. He was the single largest donor, even more than Martin Marshall of Betway, contributing to the political environment in South Africa. funding the Democratic Alliance in the main, right? Then Capitec was part of the companies that pledged 250 million to the project management office of the president just this week actually, on Tuesday. There's something here about billionaires now using money to distort democracy, to put their finger on the scales of democracy in ways that I think are worth questioning publicly. Is it ethical? Is it not an abuse of corporate power and financial power? Going to the legal side of it, Freedom Under Law, Corruption Watch, and the DA are funded by one person. They go to the court as three separate entities to make three separate applications, to make three arguments. They get allocated time 3 times. That means effectively they are taking 3 bites of the cherry, and discursively they are getting more time to argue, and in and of itself that can have a persuasive way of shifting things, because they're repeating the argument 3 times when in effect they should have made it once, because they are under one umbrella. They are. It's one thing in this instance. It's one thing. And I have concerns about one guy with lots of money going to 3 different people saying, you go on Monday, you go on Tuesday, you go on Wednesday, you'll all argue before the court. Getting the president's advocates, top advocates, such as Wim Trengove, to argue this matter. I think this is a distortion of the process in and of itself that undermines the credibility of the process. I really do. I want to go to the next point. The case for this interdict was heard by 5 judges in the Western Cape. 5, right? But it was only heard, the interdict for the JSC, by 1 judge who is relatively junior in Gauteng. I don't think that should have happened. It's very rare to have a case heard by 5 judges, but it's possible, right? The Constitution states in Section 173 that high courts have the inherent power to protect and regulate their own processes, but the Supreme Court Act states that a full bench of the High Court, and the Supreme Court Act states that a full bench of the High Court consists of 3 judges. But the second section, the Section 13(1)(a) of the Supreme Court Act provides for a hearing of a case, not by a full bench, but a full court, consisting of as many judges that the judge president or his or her second in command may determine. It was determined that the issue of Dr. John Hlophe should be heard by 5 judges, unprecedented. But it showed the gravity of the matter. Now, in this particular instance, the JSC side, Mlambo, chose the Gauteng side, which is chaired by Mlambo, who's the guy who was grilled by Advocate Dalimpofu and grilled by Julius Malema. He doesn't like them because they prevented him from becoming a Chief Justice. He's the guy that many people were reporting that he'll become the next Chief Justice. And he's now stuck as Judge President of the Gauteng. Gauteng is important, it's very big, but he wanted more. And it is conceivable that he didn't want this process to be delayed. He wanted it to happen tomorrow. It's happening tomorrow. So he appointed 1 judge to hear this issue. I think that's a problem. This issue is so technical and so serious and can be viewed on rational grounds fairly by different people in different ways. And as a result, it should have been heard by 5 judges or 3. I think that the second interdict is wrong. I think an interdict should have been granted. This thing is so delicate and so important that there was no need to rush this. There's really no need to rush this. Now, my last point I want to make is that the court said that the legitimacy of the process would be tainted by adding Dr. John Hlophe. But I think that they looked at it from only one side to say, okay, this guy who we found to be wrong or to have acted unfairly or not unfairly, in an irresponsible manner when he went to judges asking them to rule in favor of Zuma. in the arms, was it arms deal? I can't remember what it was back in the days. So then they're saying it will be tainted for him to be there. We've removed him. But they're not looking at it from the other side. You know, something can be dirty from this side or it can be dirty from this side. You have to consider both sides and you have to balance those risks. They are very, myopic in their view of what informs public perception and what informs 2.5 million people listening to you remove their guy who is a legitimate member of parliament. Are not going to necessarily view that as untainted, unblemished. If they're worried about the credibility of the process, they should have been concerned. What happens if MK wins the appeal? And now Hlophe was prevented from cross-examining or grilling or asking questions to people who are sitting in the court that he came from, where he has specialized knowledge. Do you not think that